Good morning once again, ladies and gentlemen. My name is Alvin Sim. I'm the current Executive Director of the Singapore International Mediation Institute. Welcome to Quality Assurance in the Mediation Industry, A New Dawn, a SIMI event, part of Singapore Convention Week 2022. To our guests on site, you are at the National University of Singapore Bukit Timah campus. Located within the Singapore Botanical Gardens, this is a place steeped in history. It is where the University of Singapore, Singapore's first full-fledged university, started, producing Singapore's early batches of university graduates. We're joined by about currently 90 people online representing countries from around the world to discuss and reflect on a challenging, important yet relatively invisible topic in the mediation field, quality. We will look into the whys, whats, hows, and wheres of this topic today. And to open this meeting on these questions is an eminently qualified thought leader in the mediation field, Professor Joel Lee of the NUS Law Faculty and Chairman of the Board of SIMI. Professor Joel co-pioneered the teaching of mediation and negotiation in Singapore universities. He has helped in various ways to further the development of mediation in Singapore, including being part of the Ministry of Law's working group to develop Singapore into a center for international commercial mediation. He's a SIMI-accredited mediator and on the panel of the Singapore Mediation Center as a principal mediator. Finally, he is the co-editor and co-author of the seminal book, An Asian Perspective on Mediation. Behind all these and other appointments, I know Joel as a boss and teacher who cares about his students working on this very important topic. Professor Joel, please.
Good morning, everyone. Thank you for attending today. It's sometimes a little bit challenging when you hear people introduce you and you go, who are they talking about? It's lovely to see all of you in person, and those of you who are joining us online, good morning, good afternoon, good evening, as is appropriate. Thank you for joining us. In particularly, I would like to acknowledge a number of people in the room. Judge Tien, who I understand is attending online. Mr. Sulaiman Alulayan, who is the Assistant Deputy Minister for Court Affairs, Ministry of Justice, Kingdom of Saudi Arabia. Welcome, sir. And of course, Mr. Lok Vee Ming, Senior Counsel, who is our moderator for today. We also have esteemed friends from a number of different bodies, Ministry of Law, the Community Mediation Center, SIMC, Society of Mediation Professionals, a whole list. I'm sorry, I can't mention all of you, but welcome. We're very happy to have you as our friends and as our supporters. SIMI, the Singapore International Mediation Institute, we affectionately in Singapore call it SIMI, which if you are in Singapore and have a Hokkien background, you will actually understand it comes from the dialect. It means what. So when my wife says, what do you do at SIMI, I say what? And it just, and then the conversation sort of falls off from there. SIMI is currently in its 8th year. We were created at the same time as the Singapore International Mediation Center. And we were founded by the Ministry of Law as a standard-setting body for mediators in both Singapore and internationally. The idea was that in Singapore, as we move towards providing international mediation services, it was also important that we needed to be at the forefront of ensuring that there was quality assurance and the confidence of mediation users in the mediation industry, right? So to this end, SIMI has over the years developed an accreditation framework, standards that speak to that framework, as well as promoted thought leadership in mediation. For our friends who are present, some of you are holding on to a book called The Contemporary Issues in Mediation. This actually was an initiative when it's actually our 7th year now. And this initiative highlights work done by students in areas of research in mediation. And the idea was to actually grow the next generation of people who are going to be researching and be thought leaders in mediation. So that has been fairly successful, and we're very grateful for the support of both students as well as practitioners in the field. Of course, since 2014, a lot has happened. Of course, the big thing that has happened and the reason why we're all here today is the Singapore Convention on Mediation. It's very exciting. It's always a good reason to have a party, but it's more than that, right? It's more than that. It's a very significant milestone for mediation as a profession. There's been a lot of growth of mediators, training services, provision services internationally in Singapore. But that also means there have been a lot of measures internationally to ensure either the control, the growth, as well as the quality of those providers, whether we're talking about service providers or training providers. For example, there's the mooting of Thai legislation to ensure that, to mandate the training of mediators, for example. In India, I think that the legislation is going through the parliament relating to various mediation initiatives. And in Australia, as far as I understand, there is actually a Mediator Standards Board review right now, right? And SIMI, of course, right now is also going through its own core competency reviews and all of that. So that's a lot of that's happening at the moment. In Singapore, it's also been particularly exciting because we've recently had come into effect the Rules of Court 2021. And that came into effect on the 1st of April, 2022. And essentially it's basically encouraging mediation, that disputes needed to go to mediation first unless there was good reason, right? And this really means that a couple of things, that mediation is being considered at the correct times, but it also means that mediators, people who are interested in mediation can simply say, okay, well, this is a good chance for us to play a role in ensuring that disputes are resolved in a professional, sustainable, and positive sort of way, right? With the increasing interest in mediation internationally, the question of professionalization has become more acute. And one of the reasons why our panel is here today is to explore exactly that question, right? And I'll say a little bit more about that. I just want to sort of share some ideas about what it means for us to professionalize. What does that mean, right? And there are disputes about, well, hang on, in order to become a profession, must that actually mean, okay? I'm not sure Singapore is in that position yet to have that conversation, but some countries are. But I think we're moving in that direction. But I would say a couple of things, I think, in terms of what we say professionalization means. Number one is that at some point it becomes a viable professional career option for people who are interested in the industry. And that means a couple of things. The first, I think, is that there needs to be a little bit more creation of demand, right? I think it's a common problem that there are more mediators around the world than there are cases, but some of it is not because the cases aren't there, but because cases are just not being referred necessarily to mediation, right? And people are not aware about what mediation is and how it might help. So that one of the things is, of course, the creation of the demand. The second, of course, is to ensure that mediators and mediation advocates get paid fair value for the work that they put in, right? I think one of the challenges that we've always been saying mediation is cheap. I think more accurately, mediation is cheaper. But the moment we call it cheap, then we start, billing for our time fairly. People go, but I thought you said it was cheap, right? So I think we need to sort of, be a bit nuanced about how we sort of, sell mediation and explain why mediation is a good thing. So that's the notion of what it means in terms of demand and what it means to be reimbursed or recompensed for our efforts. But on the flip side then, equally important is the assurance of quality. If we're going to rely on mediators and mediation advocates as professionals, there must be some way for us to say, well, hang on, that person is a good mediator, got quality, right? And of course, in Singapore, we are notorious. We like cheap and good, right? But it's always good, must be good, right? And so one of the questions is, how do we assure quality in our industry? There are two aspects of this. The first is entry level. What should be the qualifications of someone who says, I'm going to be a mediator, right? And without either some framework that says you must have these things, anybody, any Tom, Dick, or Sally can put up their shingle and say, I'm a mediator, and you can't dispute it, right? And so what SIMI is hoping to do, at least at sort of a private, national, and international level, is to say, hang on, as an independent standard-setting body, and when we say independent, what we mean is that we don't provide mediation services. We are not pushing that. We're simply saying ISO 9002, whatever the independent standard is, we're saying these folks are good mediators, good mediation advocates. And that's what we're trying to aim for, right? It's, of course, a little bit challenging having agreement, discussions, consensus on what is the benchmark, what are the standards that should apply. And that's okay. It's okay to disagree on these kinds of things, right? But what's important is that we have to have the forum and the maturity and the ability to talk about these things, right? Which brings us then to today's panel. I feel a little bit like Nick Fury, because when we say, we assemble a panel, so this is like the Avengers assemble, but we have assembled a panel comprising of mediators, mediation advocates, in-house counsel, stakeholders, and leading thinkers in the industry, right? And so let me first thank our moderator, Mr. Lok Ming, and our panelists, whom Alvin will introduce later, to you. But thank you very much for helping us, further this mission in this endeavor. We hope that today will allow us to explore and have meaningful conversations about how we can professionalize mediation, what professionalization in the sector actually means, and what kind of infrastructure is needed to support that, right? SIMI as a body, as an infrastructure body seeking to champion and uphold standards, we hope today's panel is a good starting point for that conversation, right? We hope that we will have a conversation today about standards, quality assurance, and we will continue to lay the groundwork for that conversation and for standards to go on in the future. So I look forward to an active and lively discussion. I know I'm standing between you and the main event, so I'll shut up very soon. But I also invite the audience to participate, ask questions, and of course, for those of you online, welcome. We have please submit your questions online, and we will curate them and post them to the panel. So folks, have a very good evening. Sorry. It's been a long week. I apologize. It's been a long week. I haven't had enough sleep. I apologize. Have a good morning, and I'm in the UK right now. Have a good morning, and I hope you have a good panel discussion. Thank you very much.
Thank you, Prof. Joel. And for those of us who have just joined us online, this is, once again, Quality Assurance in the Mediation Industry, A New Dawn, a SIMI event part of Singapore Convention Week 2022. It's now my pleasure to introduce the moderator for today, Mr. Lok Ming. Mr. Lok was appointed Senior Counsel in 2005 and is one who wears many hats. But with these comes a man with purpose and mission. As a leading aviation and insurance lawyer and arbitrator in Singapore and abroad, Mr. Lok led successful defense teams some 2 decades ago to elicit the truth during lawsuits surrounding 2 dark patches in Singapore's aviation history, the MI-185 and SQ-006 incidents. And Mr. Lok, I do know Siu Hui from CAS. My wife was working with her at that time. In service to others, Mr. Lok has been a president of the Law Society of Singapore and still serves on its Professional Indemnity Committee. He is on the panel of both the Singapore Mediation Centre and the Singapore International Mediation Centre. He's also the Deputy Chairman of the SIMC. Besides his busy and wide-ranging commercial dispute resolution practice, Mr. Lok was also known as a heart for nurturing younger lawyers. So, Mr. Lok, over to you this morning. Thank you very much for coming, and I'll let you to introduce the panel. Thank you.
Thank you very much, Alvin, for that introduction, and just wasn't quite sure who you're introducing, and Joel had to give me a nudge to get up onto the stand. It's a great pleasure this morning to meet all of you and to be moderating this session. On my way to the NUS law faculty here at Bukit Timah, I had my car radio on, and the DJ was saying, well, the next song is really a favorite with many of us, and it's a song from Queen, and it's We Are the Champions. And the first opening lines of the song go something like this. I'm not going to sing it, but it goes something like, we are the champions, my friend, and we will keep on fighting to the end. We are the champions, No time for losers, we are the champions. This is a mantra and an anthem for many lawyers and many law firms. We want to fight our cases, we want to fight our battles, and we want to win. All right. If we win, and if we resolve the issues between the parties, that's great, but we must win. Right. I remember when Chief Justice Chan Sek-keong was interviewed on his taking on the post as Chief Justice. The interviewer asked him and said, Chief Justice, the last time I interviewed you was probably over a decade ago, and you were a judge of the High Court, and you went on to become the Attorney General, and now you are the Chief Justice. Is there anything that's changed in your approach to lawyering or to being a judge? And the Chief Justice then said that, well, in the earlier stage of my career as a judge, when parties came before me, I was very keen to find out what are the legal issues between the parties and to see how I can resolve those legal issues. But now I think I'm more keen to find out what are the problems between the parties and to see how I can resolve those problems, of course, within the limits and within the guidance of the law. And that, I think, has come to exemplify and to define for many of us the work of mediators. All right? Sometimes it's still about winning and losing, but that no longer becomes the all-consuming objective. And in mediation, as Professor Lee has said, it is important. The mediator plays a very important role. So today we talk about quality assurance. We use this term to refer to electronics. We use this term to refer to fruits that we sell. How do we assure quality of the product that we are pushing out? And in a sense, mediation is a new product, a relatively new product to many of us. It is a product that we think works and sweetens the deal for those of us who are in the unfortunate and often frequently bitter business of resolving breakups and fractures in relationship. And but how do we have and engender confidence in people who play a very important role in this process? And that's the mediator. So today, I'm helped in this discussion by 4 eminent practitioners and thought leaders in mediation. I'd like to invite all of them to join me here on stage. Mr. C. Chern Yang, who is a director of Napier. We'll have Associate Professor Dorcas Quek from the Yong Fang House School of Law, SMU. And I would like to invite Nishtha to join us. And she's Chief Legal Officer of MBK Healthcare Management. And last but not least, I'd like to invite Anna Goncalves to join us up here on stage. Right, so our speakers will be presenting to all of us some aspects of mediation or of how we can improve or increase the level of confidence in mediators. And we want to invite questions and participation and interaction with both those on site as well as those online, all right? So you can ask your questions at any time. We will choose an appropriate time to answer them. If there are questions that we are unable to handle, we are very grateful that we still have Professor Joel Lee, who is still comfortably seated here in our midst. But without further ado, I'd like to invite my friend, Chern Yang, to kick off the presentations this morning. And Chern Yang is a litigator. He is a director with the dispute resolution practice in Napier. He's a seasoned mediator one of the youngest to be appointed principal mediator at the Singapore Mediation Center and an international mediator at the SIMC. He is also appointed to the panel of mediators at WIPO Arbitration and Mediation Center. He regularly teaches mediation and has done so for the judiciary in Brunei, Thailand, Myanmar, and government officials in Fiji. He has also authored a few chapters on mediation and family law. Let's welcome Chern as he speaks to us about professionalism in mediation. Thank you, Ming. Thank you, Ming.
It's a pleasure to see everyone with masks off. I had some problems initially when the rule came up. You sometimes cannot recognize people with or without their masks, right? But let's move on to the topic. And this topic of professionalization and professionalism within the mediation industry is something very close to my heart as well. Besides the legal practice, the disputes or litigation side of the practice, I am involved in a few mediation societies. So one is the Society of Mediation Professionals. The other one is actually currently for this year, I'm the co-chair of the Law Society Mediation Committee as well. So I'll share with you certain things. Now, Prof. Joel early on talked about what it means for professionalization, to be professionals, to be a group of professionals. And I was mulling over this in preparation for this discussion today. And I looked up, and one of the interesting definitions that I found is taken from an extract of an entity in Australia. It's called the Australian Council of Professionals, which is really an alliance of professional associations in Australia. So it includes engineers, vets, and various groups of professionals in Australia. And they define a profession as this, and I quote, "A disciplined group of individuals who adhere to ethical standards and who hold themselves out as and are accepted by the public as possessing special knowledge and skills in a widely recognized body of learning derived from research, education, and training at a high level, and who are prepared to apply this knowledge and exercise these skills in the interest of others." They go on and explain that it is inherent in the definition of a professional that a code of ethics governs the activities of each profession. And the codes would then require behavior and practice beyond the personal moral obligation of an individual. They define and demand high standards of behavior in respect to the services provided to the public and in dealing with professional colleagues. And often these codes are then enforced by the profession and are acknowledged and accepted by the community. So that's how the Australian Council of Professions defines what it means to be a professional. And to me, that is something the mediation industry in Singapore needs to move towards. And actually, I would argue, has been moving towards over the last number of years since the start of the SIMC structure, the SIMI, the incorporation of SIMI as well. So one of the things that has come up in the past, and why I say there's been a movement already towards professionalizing it, is that in January 2015, there was this bunch of mediation nutters, and I was one of them, that really banded together and said, we need to do something to push this towards professionalization. And we then got together and we formed this Society of Mediation Professionals in Singapore. And what we have done since then is really working hand in hand with our colleagues in mediation, with various organizations, training service providers, SIMI as a standard setting body, and getting feedback from the ground of the mediators and the mediation stakeholders about the profession, mediation as a profession, about mediation as an industry, and how do we move forwards. The society also helps in terms of pushing knowledge, education, continuing professional standards, in a sense, setting a certain level of continuing professional development for our mediators in the industry. So that has been something that we're working towards. We're obviously in discussion with SIMI as well, been invited, very gracious of SIMI to extend an invitation to us to be involved in some bits of the review of the standards that we have or the standards that we want to start both locally and internationally. So that is something that the Society of Mediation Professionals is working towards. And if you think about it, we have parallels in various other professions. We have law society governing lawyers. We have Singapore Medical Association, and a lot of these professional bodies always have that society or the body that the community comes together. So that's one bit that has been developing over the years, and I think it augurs well with SIMI being a standards body and a certain industry community of mediators always being there to support each other. The other thing that comes with professionalizing, I think, is Joel mentioned SIMI starts looking at the base level entry requirement for knowledge and skills. And I think one other development that will come or has come in the years and will continue to come in the years ahead is a certain area of specialization for mediators that require specialist training. So we've seen now in Singapore, you've got specialist training for family mediators, you've got specialist training for IP mediators, you've got specialist training for community mediators. And I think that's the way to go. General mediators at the starting entry point in the build-up of professionalizing the sector is unlikely to be sufficient. Or let me reframe that. A general knowledge of skills and basic qualification is not likely to be sufficient if we want to professionalize the industry. And again, I look around at the various professional industries that we have. We've got specialized lawyers. You don't go to a corporate lawyer if you've got a criminal charge laid against you. You don't go to an orthopedic surgeon if you've got a heart problem and require a heart transplant. And that's the way likely mediation will go. The medical negligence disputes will probably go to mediators who have a sense of specialized knowledge, experience dealing with those. Those having community disputes will go to the mediators who have the specialized knowledge and skills to deal with those disputes. And that is another area which I think will drive professionalism towards. The downside to that, of course, is yes, it means a lot of us will have to continue our professional development and education. It means spending more time getting ourselves trained in the various specialist areas. But I think it's important in the movement towards professionalization that needs to happen. So that's all I have, Ming, for now, and then we'll take maybe questions and discussions from those points.
Thank you very much, Chern Yang, and I think that's thought-provoking. This whole question about professionalism isn't just about making sure that a mediator has the skills to bring parties to a position where they can be at, but in this world where disputes are getting increasingly sophisticated, we need mediators not only to have the necessary skill sets, but we also need mediators who are armed with the necessary knowledge that is important background, to helping parties get onto the journey to a settlement. Well, we will, of course, dissect that a little bit more in the course of this morning. I'd like to now switch to the other side here of the table and invite Nishtha to give the next presentation. Nish is a distinguished technology and innovation-focused lawyer with over 16 years of experience in handling complex legal and regulatory issues, particularly in the Asia-Pacific region. She's presently the Chief Legal Officer at MBK Health Management. It's a wholly owned subsidiary of Mitsui & Company with a mandate to grow the healthcare ecosystem of Mitsui with investments in leading healthcare providers such as IHH. She's been nominated among a select panel of UN WIPO's neutral arbitrator mediators in Asia, and previously in her role as legal director ASEAN, Japan, and Korea at Reckitt, she managed legal affairs contributing towards the innovative solutions to people's everyday challenges in the arena of health and well-being. I think it's extremely refreshing, gives us a special insight from another aspect of the legal industry, as an in-house counsel, as a consumer of legal services, to tell us from her perspective how mediation has helped, how mediation could have been better, and how quality assurance for mediators is a very important quality, is a very important thing to have within the mediation industry. So let's welcome Nish for her presentation. Thank you, Nish.
I think you are one of those few people who look younger than their picture, Mr. Law.
Oh, thank you very much.
You have lost chubbiness here. I'm grateful to SIMI for giving me this opportunity and thinking about of in-house legal perspective. It's a great honor to be here before the August gathering and to share a bit of the experience that I have had in mediation as an in-house counsel, where we were consuming mediation as a services. So, I know I've been given 10 minutes, and I would like to conclude my thoughts within 7 minutes, so that we have 3 more minutes to have any further discussion if you would like to have. So the first biggest challenge that we face when we are talking about mediation is how to position mediation as a product before our managers. When there's a dispute, you'll be surprised that managers are trained that dispute means going to court. Arbitration has done a fantastic job that now the word arbitration also sits on the lips of our CEO. They do not understand what it means, but they understand that it is one and the same thing. So when you broach mediation, their responses are, what do you mean? Are you asking me that I'm going to have further communication and it's going to further delay the outcome? So one of the objectives of CEO is to inform their shareholders or in the board meeting as to what's happening in terms of resolving the dispute. If it's litigation and you're a listed company, then you have to inform, right? If it's arbitration, again, you have to inform. But when it comes to mediation, that's a challenge. That should you inform as a listed company that you have an ongoing mediation or you do have a dispute? So not to recognize the issue as a dispute is one of the critical skill set that an in-house counsel needs. Because until you have not recognized it as a dispute, you are not resolving it through arbitration or litigation. So that's point one. The other experience that I had while, again, speaking with CEOs that we should try to resolve through mediation, the question they will ask, is it in the contract? Why are you proposing something new? Again, the concern is that am I trying to delay the whole process of concluding the issue, or am I making it difficult for him to inform his manager as to how we are resolving it? No. So I must thank Australia in terms of, in this part of the region, in leading, I think they are leading in terms of making sure that public contracts, specifically in healthcare, they all have embedded mediation process, beautifully laid out as to what, and it's not about, it's mediation clause, how mediator will be appointed, and the time period within which mediation has to conclude. Now, when you have that clause, it's easier for me to answer that question. Yes, it's embedded in the contract. When you don't have that clause, then what do I need? I need training from SIMIs and others, and these conferences like this, and some examples like Chern has shared that how he is helping his client to resolve dispute. And then the conversation grows from there. So that's the biggest challenge, how to position mediation as an effective tool to resolve a matter. I'm not using the phrase dispute, as you can see. So the three challenges that I would like to highlight in terms of ensuring the outcome of mediation, quality of outcome of mediation, when you are winning trust of your CEO, that it will lead to an outcome. I'm not saying that whether we will win or lose, but it will be an outcome that we'll be looking forward to. The first mistake that we generally make is about not checking the contract. So either you have a situation like Australia, checking the contract, you have a clause, or you don't have a clause, but you do have a clause that talks about discussions at committee level. And I do use that clause to convince my managers that we should go ahead with mediation. So that's point number one, the mistake that we do, that do check your contracts. You may have mediation clause there. The second thing that needs to be checked is that in some jurisdictions, even if you don't have mediation in your contracts, the courts are more supportive of mediation. In fact, in Singapore, in one of the, I've been mentoring a blockchain company, homegrown blockchain company, and it is in litigation right now. We are seeing that the registrar, if the other party has proposed mediation, registrar has instructed the party that have you written to them formally. So that mindset is coming, where you may see increasingly in future that courts will be supportive of mediation as they have been supportive of arbitration. So the third point is about selecting a well-trained mediator. Again, to Chern Young's point, I'm not going to elaborate on that further, but the phrase here is industry expert. It's true, you do need an industry expert who, so for us, industry expert means the one who will understand the industry where we are operating. Two, will also understand the nitty-gritty of laws. And third, who will understand that mediation doesn't mean litigation. So we do get concern as in-house counsel if there's a name of a top litigator, because we want to be convinced that he will not wear a litigator hat. So I do agree with your point, Mr. Joel, that professionalism would mean a total change in mindset of the lawyer, that mediation means that you're wearing different set of clothes, not just hat. You have to change everything within yourself. So let me just quickly touch on the mistakes. The first one that we in Australia, when we were preparing for mediation, we realized that we were not aware of the strengths and weaknesses of a case because we have not prepared for litigation. So if you are jumping to mediation in the middle of litigation, then you are aware of the strengths and weaknesses. But if mediation is your first pit stop, then please do prepare for your strengths and weaknesses. The second point would be that, again, an experience that I was having a call, I was on a call because I was not in Australia during the mediation, that can I sign this? Can I agree to the limits, upper limits and the lower limits? So if you do not have thought about this before, saying that we will see, then I'll be very honest to my CEO, that do not claim that quality of mediation was not great because we could not sign the settlement agreement. So please do have this discussion beforehand in terms of upper and lower limit an individual can agree to during the mediation, because mediation is not a lengthy exercise. It's a matter of day or two. Third, I just realized in another matter, we were not having a draft settlement document ready. All we have to do is that we have to leave some blanks empty. By not having that, we actually couldn't get the outcome from mediation because parties were like talking, and we could not capture it in a draft settlement document. And we are thinking of now redoing the mediation. So please do have a template of your settlement document ready, which you can just quickly present it at the conclusion that let's write down the blanks together. Well, that's the taking on the words that you mentioned. I kind of liked it, loser. So do not use the word lose. Mediation actually means not winning or losing. It's not about being right or wrong. It's about middle path, which Buddha also suggested, middle ground, to land on a middle ground, where one will say that what are the things we can let go so that we can say let's go. That will be my conclusion on this topic. Thank you.
Thank you very much, Nish. It's always very refreshing to hear the perspectives from an in-house counsel and to see from what you have experienced some of the pitfalls that are very easily avoided when one enters a mediation session either unprepared or not fully prepared to work towards a settlement. And I think many times we go into a mediation session, let's see how it goes. And much of that emanates from a lack of understanding as to what a mediation session is and what it can achieve. And I like the way you started, Nish, by saying that actually quite a number of CEOs or heads of companies and departments do not fully understand what mediation is. This brought to mind a little story I had some years back when we were trying to promote mediation around the region. And I was in Myanmar giving a talk on mediation. I don't know, Aloysius here, who was the former CE of Singapore International Mediation Center. I'm not quite sure whether you were there with me. But I had some of our staff put up slides in Myanmar language for me. And then when the first slide went up, I saw some smiles in the audience. And after my talk, I came off of it. And one of the generals, I think, came up to me and said, thank you very much, Mr. Look, for that talk. I think there may be something wrong with your first slide. I said, no, what does it say? It's supposed to say mediation. It says, no, this is a talk on meditation. So I say, well, maybe there isn't that much of a difference. You just sit back, take a deep breath, and just hope that things turn out okay. That's not quite entirely true about mediation, and I think we need to talk about mediation. We need to make our mediators more professional. We need to teach them. So we've moved from the practitioner, we've gone to the user, and now I think we need to get on to the teacher. Associate Professor Dorcas Quek, before she, in her present appointment as the Professor of Law, she was a judge with the state courts. And she has a great deal of experience as a mediator, and her research is drawn from her experience and her interaction between dispute resolution developments, access to justice. Her research has been published in leading international journals, including the Civil Justice Quarterly and the Harvard Negotiation Law Review. I'm quite sure we're all waiting to hear from her. Let's put our hands together. Welcome, Associate Professor Dorcas Quek. Dorcas.
Thank you, Vivian, for those kind words. I also like to thank SIMI for inviting me to be here. Prof. Jolie, we have Alvin too, I saw Kian Yip also in the background working very hard. Yeah, so we have just heard about, we started off with what is a profession. And Nish has really has also given a very invaluable perspective on quality, if I could say mediation advocacy, when you prepare a client, how they can be prepared for mediation so that you have a quality mediation process. So what I will be speaking of, it really is expanding on what Chern mentioned when he gave the definition of a profession. Right? You notice they said they are a body of people, discipline group, I remember the quotation, discipline group who adhere to ethical standards. And then there's something about they also demand high standards of behavior. So I'll be talking about the significance of mediation standards and linking it to why we are here this week in light of the Singapore Convention on Mediation. Right, so it has been a couple of years since the signing of the convention, and we in Singapore affectionately like to call it the Singapore Convention. And we want to see how mediation standards actually play a greater role. So I believe that they have attained greater significance in light of this landmark development, the signing of Singapore Convention, and it will increase as we have more ratifying and more being parties to this convention. So essentially we heard from the first few days that what this convention does, it creates a harmonized enforcement framework for settlements arising from cross-border commercial disputes. Right, so it's meant to plug the gap that whereas sometimes maybe reservations from going to mediation could stem from doubts whether it can be enforced across countries. Now this provides an enforcement framework that can really give teeth to settlements that we have, even when we are doing mediations across different countries. So when this development came about, I was thinking to myself, so mediation standards, I had this discussion also with Chern, I'm also part of the Society for Mediation Professionals. We were thinking, what is the significance of mediation standards? And also trying to foresee what will happen, right, once the convention comes about. What does it mean when we apply mediation standards? This is just something I wrote in terms of my thoughts, and a lot of it I always like to put in writing. And essentially, I'm saying that the mediation standards, and the moment I talk about what these mediation standards are, they attain greater significance. Their standing actually is elevated in light of the Singapore Convention. And why so? You look at Article 5 of the Singapore Convention on Mediation. In any kind of enforcement mechanism or treaty, just like a New York Convention, you need grounds for non-enforcement. So it can't be anything gets enforced, right? So there must be some kind of criteria, some kind of benchmark to decide whether something is enforceable or not, and also when something should not be enforced. So you see at Article 5.2, which is the box on the right, you notice that Article 5.2E, right, so I not put all the words there, when there's a serious breach by the mediator of standards applicable to the mediator or the mediation. And then it's quite a high threshold, without which breach that party would not have entered into a settlement agreement. And then F, is related in the sense that it's a specific type of standard that's being breached. So the standard here is about impartiality or independence. So if there's failure by the mediator to disclose to the parties circumstances that raise justifiable doubts as to the mediator's impartiality or independence, and again, that's a high threshold. Such failure needs to have a material impact. So this means actually, if you just look at the top right corner, if we take a step back, so we are celebrating, in a sense, and it's a good thing that if more countries come together, we have a means to enforce the settlement agreement, right? But it also means that they won't be enforced, and the condition when it won't be enforced is that there's a serious breach of mediation standards. So my first point on the top right-hand corner is really, before the Singapore Convention, a lot of mediation standards are embodied, say, in codes of mediation conduct. They might be articulated by mediation institutes, say, Singapore Mediation Center. They might be, say, in international accreditation or standard-setting bodies like International Mediation Institute and SIMI, which does not mean what, but actually very important. They have a code of professional conduct and a very, very important and detailed code of conduct as well. So it means that in the past, whereas there used to be maybe soft regulatory codes, especially in early days where we were trying to build some respect in the profession, now they actually have been elevated in standing to standards that if breached, serious breach notwithstanding, they can impact legal enforcement. So that leads me to the point at the top left-hand corner. It does mean that actually we need certainty about what amounts to serious breach of the applicable mediation standards. Of course, it's a very sober note when we talk about breach, and sometimes you don't want to talk about it, like it will never happen. But it does mean that we need clarity about it. Mediators need that clarity. Parties who do the mediations cross-border would, and the lawyers advising them would need to know. And so we come to the third point, if you look at the bottom left corner. So I'm arguing that we actually, even before you convene a mediation and you are anticipating, I want to make use of the convention for enforcement later, we need to know also what kind of mediation standards are we convening the mediation upon. This is where you look at Article 5, they are saying the standards, mediation standards that apply, that are applicable. So it normally will be very clear which code of conduct we are using. Say, are we saying that this is convened under the IMI code of conduct, for instance? So that addresses one of the questions I see in the Q&A. What are mediation standards? So you can see it can be any kind, right? Because it depends on the parties, the mediators, to be on one page to say, I put myself out, I'm going to adhere, say, to SIMI Code of Conduct. So those then will be the applicable standards. And it might differ from code to code, what these applicable standards are. So in terms of understanding what the mediation standards mean, this is where I'd like to elaborate a little on the profound implication of standards. They not only impact enforcement, but actually if you look back as to how mediation started, a lot of these standards actually embody values underpinning mediation itself. And we know that the attraction of mediation ultimately depends on how the mediation is conducted. It's not really on whether there's settlement or not, actually, you look at it. Because when you talk about mediation, we talk a lot about experience, right? So when we talk about quality assurance, we are thinking about, is there a positive experience parties have in mediation? And that, I suggest to you, is paramount. Because if you look at mediation, this harks back to, there was a very light-hearted debate this week on mediation, arbitration, litigation, whose kingdom prevails, right? But when you actually think about mediation and see how it's distinctive from many other adjudicative processes where a decision is made, you notice no decision is made it's by the mediator, and unlike a trial, arbitration, you can assess, okay, the soundness of the decision made. Is it according to these principles? You look at what's written. But how do you assess whether mediation is done well or badly? Very different basis, right? If you think about it, totally different basis. It's the process itself. You don't just look at outcome, okay, the settlement agreement, then you peruse the settlement agreement and the terms, right? Quite different altogether. So this means process is paramount to ensure a positive quality experience in mediation. And in this regard, I'd like to say a bit about this concept of procedural justice. This is a concept I use a lot in my research, and it's close to my heart, also because of my own experience as I started in mediation. Procedural justice really is research, and very robust research at that, in psychology, in many areas, even government, to show that ultimately the party's opinion on the fairness of an outcome hinges not really on the substantive soundness of the decision, but really on the quality of their experience. And interestingly, this research first was done in terms of police. They were trying to see what links to people's impression of legitimacy of the police. And in police, in government, in the courts, they could, with very, very robust research, show it boils down to 4 aspects in terms of the quality of experience. Whether they were treated, 1, with dignity and respect, 2, whether they were given voice, 3, whether the third party was even-handed, neutral, impartial, transparent. 4, whether the person conveyed trustworthy motives. Notice all 4 of them, they sound very intangible, but they all relate to the process. And you notice some of them even are really principles we find in codes of mediation. Things about voice. Voice relate to, are you able to participate? Do you exercise self-determination? Do you exercise your party autonomy? Dignity and respect are related a lot to either voluntariness. Even-handed neutrality is a very great principle, right? Impartiality, seminal principle in quotes. So the main point I'd like to stress is that the true success of mediation is not determined by whether a settlement is reached, but how the mediation is conducted. And although we recognize this, sometimes it doesn't sink in, even for us as practicing mediators. I recall when I first doing mediations, I had a series of not settled mediations, right? And then it can make you really demoralized. Not settled, not settled, not settled. And then you think, what good am I as a mediator? And it took a while for this to sink in, that what really determines a success is how I've done it. And if we truly believe that the settlement outcome is not the determinative aspect, but how you've done it, it will affect how you do your practice in terms of you give utmost attention and emphasis to how I do it. Knowing that that really affects the experience, you will know that even if I have reached a settlement, it might not necessarily have been a good quality mediation, because I might not have done it well. So it took a while for me to really see that the perceived legitimacy of mediation, especially the parties, is really lies in how I do it. And how I do it means that we must have some guidance on how we do it, right? It can't be anything goes. And I realized that if we don't talk about it, and if we ourselves as mediators don't understand what these principles and quotes mean, if they are merely vague principles and words, then it is very risky. It is actually very dangerous for the future of mediation, even though it might be embraced and is used more. Because as soon as more people use it, the moment you have a marred experience, a bad experience, that might mar the legitimacy of mediation. Not just in Singapore, the whole wide world. So I'll end really on talking about the critical importance of understanding mediation standards, therefore. So I think the main thing, first step is to understand, gain an accurate understanding. And we know that this is not easy. Prof. Jolie was mentioning sometimes we even talk within in one country, what standards should be there? What do they mean? And we find that we all have different views. So it's not easy to reach the understanding, but as he mentioned, it's not a matter of reaching that unanimous agreement, but really understanding the differences. So it might be a difficult conversation, but what is the meaning, for example, of self-determination? Self-determination, for instance, is a quintessential characteristic of mediation. Even the Singapore Convention, Article 3, says that mediation is a process, regardless of expression in which it's used, where they attempt to reach an amicable settlement with assistance of third party lacking the authority to impose a solution. Right? But how has that worked exactly? When can self-determination be really undermined such that you no longer call it mediation? And then if we talk about cultures, when will you know when self-determination is being impinged? Right? Different people might show their discomfort in different ways depending on their communication styles. I realized that even as a former judge when I practiced mediation, when some people ask me for my views, I also have to be quite aware, watching their body language. As they respond to my views, are they feeling pressurized, right? Or do they still have that autonomy there being well exercised? So we actually have been doing this in the last couple of years, very intensive discussions. I'd like to point to the work of the IMI Ethics Committee. Mr. Lim Tat also, both of us from Singapore are in that. And we have been looking in terms of IMI, should we, just like in, for SIMI code, how to strengthen it. And we realized that there are standards, but we need to be really talking not just the standards, what they are, but how they work out in practice. And it's really enlightening for me because the members come from all over the world, the US, headed by Omar Shapira, who's from Israel, we have from UK, we have from Europe, from South Africa. And I think those conversations is something that we need to have as mediators. We need to talk about how these principles are worked out in different contexts. We cannot expect the courts or parties to understand if we don't ourselves understand how they are worked out, if we don't understand how our differences impact the way they are worked out in different mediation traditions. And we do not want to wait for that conversation to start only when someone is disputing the enforceability of a mediated settlement. So with that, I would just like to say it's more important now than ever with the Singapore Convention as we increase awareness on mediation to also concurrently talk about standards and know how they work out. Thanks.
Thank you, Dorcas, and indeed I think you made a very pertinent point that, of course, in mediation, where parties end up with at the point they want to be, that's important, but just as important, and perhaps more so in some disputes which are a little bit more difficult to resolve, the process is important, and how parties come away with an understanding or an appreciation of that process is important. It's just like one of my clients who told me once, that when she started working in Singapore and when she wants to take a holiday from Singapore, of course the destination is important, but when she gets to Changi Airport, now here I'm trying to sell some goyo, all right, in local terms, I'm trying to do some marketing for our Singapore tourism industry. But she says that when she gets to Changi Airport, And when she gets on a Singapore Airlines plane, so I'm doing marketing for Singapore Airlines, the holiday begins at Changi Airport. All right, so it continues all the way until she gets on to the destination. And I think in a sense, well, yes, mediation can be like this. If we are building an ecosystem, we are having more buy-in from the industry for mediation, we need the carriers of this dispute resolution process to be well-trained, to be professional, to be bound to certain ethical standards, which applies not just to one country or one destination, but they are applied in a fairly uniform and universal way across different countries. And Dorcas talks about the post-convention world, and we all know now that we are really looking at very good prospects of being able to enforce settlement agreements that is reached in a convention country being enforced in another convention country. So we are looking to see whether there is a universal protocol or a universal code that can ensure that mediators have an acceptable standard of competence, of ability, of effectiveness, and of ethics. And in this post-conventional world is very important to talk about that. And that brings us to our friend Anna, who gives us this international perspective in harmonizing the standards of mediators around the world. Anna is a panel mediator in several major international mediation institutes. She holds more than 30 years of experience as a business leader in the international corporate world, as a lawyer, as a teacher, mediator, and organizational developer. Anna is the founder of the Institute for Certification and Training of Lusophone Mediators, the leading mediation certification organization in the Portuguese-speaking countries, is a mediator in the Global Mediation Panel of the Office of the Ombudsman for the United Nations, and a fellow of the NCTDR. Ladies and gentlemen, we are very fortunate to have Anna here with us to talk to us about, well, maybe is there a universal standard or a protocol for mediators around the world? Let's put our hands together to welcome Anna.
It's okay? Good. So, dear dispute resolvers and other colleagues, thank you for inviting me to participate in this event. We already had the chance to participate to a couple of fascinating sessions during this week, and I feel really blessed to be here today. It's a truly pleasure for me to talk to you about a subject that is dear to me and to anyone involved in international commerce. In the next 7 minutes, I am going to speak about the convergence in international mediation practice standards and the important work being undertaken via a universal protocol to drive professionalism in mediation across borders. Let me share with you why something is missing today to make mediation mainstream. Mediation today can be compared to this beautiful field. The flowers are all tulips, but they are of many colors. Mediation is practiced differently in different regions or countries. It's beautiful, isn't it? Everybody in the room is saying yes. I hope that everybody at home is saying yes too. However, especially for those of you who are mediation professionals, I invite you to think twice and challenge this vision. As a mediation professional, I'm naturally inclined to use this photo of tulips because I believe mediation is beautiful, I believe that diversity of mediation styles is beautiful, and because I have a way to define what all forms of mediation have in common. I am the victim of the very famous syndrome of Annie's Nim once said, we don't see things as they are, we see things as we are. Based on what we hear from users and lawyers that have international or cross-border disputes, mediation must probably rather looks like this to them. Or, if you want to be a little bit more positive while practicing constructive self-criticism, maybe mediation look like this. Which one should I choose? Why? They all look alike. but they are all different. For sure, the Singapore Convention creates more certainty. For sure, mediation certificates and schemes and alliances between international mediation organizations as well. But something is missing, something that will help users and lawyers to have more certainty about what mediation will mean when they choose their mediator. As you know, the beauty of mediation compared with other dispute resolution processes comes from its flexibility that allows each mediation to be tailored to its context, while at the same time being a professional process practiced by professional mediators. Said differently, and to stay with this metaphor on this slide, users may better choose a dumbbell, a kettlebell, a barbell, or a medicine ball. Depending on what you choose, your physical activity will be different, right? Depending on the mediator and mediation process that you choose, your emotion, your social and cognitive experience will also be different. And as Professor Doctor said very well, it is crucial to gain an accurate understanding of existing mediation standards across different states and organizations, and to understand what these standards mean in practice. So, how can we create in the mediation stakeholders' mind more certainty about this? Enters the Universal Disclosure Protocol for Mediation. The idea emerged from discussions between me and Daniel Rayner and myself, and has been presented for the first time at the Singapore Convention in 2019. As I will share with you in a while, we refined our approach by consulting many professionals and institutions all over the globe. The purpose of the protocol is to frame the multitude of mediations modes in a way that is understandable by any party around the world, by giving guidance to mediators regarding disclosure of information about the mediation process. Therefore, it gives certainty to parties regarding the mediation environment in which they are entering and the behaviors they can expect from the mediator. As the ancestral mediation notes 21 states on the topic 4, conduct of mediator, B58, initial consultations, and I quote in a summarized way, once a mediator is appointed, the parties and the mediator work out the best arrangement for the case. The principles driving the definition of the protocol are that the protocol must support self-determination, acknowledge cultural influences, the protocol must promote transparency and respect the flexibility of the mediation process. So let's look at the substance of the protocol. The protocol includes 6 elements for disclosure: conflict of interest, confidentiality, general process, role of the mediator and parties, technology, impact of union. Mediators who endorse the protocol commit to clarify their relationship to the 6 items listed above. Other items or specifics regarding subtopics may be added by the mediator to accommodate a wide variety of mediation modes and process. As I said, the UDPM is a fruit of many consultations around the globe, and today is a framework that has been validated by professionals and stakeholders from many countries. Working groups around the world with professionals that define and validate these items for disclosure that I listed previously. Furthermore, several points of consensus come from these working groups. Mediation needs this global initiative, guidance for mediators regarding what to address with parties, particularly in instances where mediation occurs in cross-border or multicultural environment, is a valuable resource. It is useful for the parties to understand what mediation is. It does not kill the flexibility of mediation. It is to be used at the start and during the mediation, and all the groups said, keep it simple and short. So this is where we are today, a validated protocol and the beginning of adoption. Here are some of the organizations that have already endorsed the protocol around the world. I can only encourage you to go to the QR code and do the same. And to conclude, the UDPM is a significant step ahead. It helps validating mediation as a high-quality process to solve international commercial disputes efficiently and effectively by creating, in the user's mind and in all stakeholders' mind, certainty, credibility across cultures, religions, legal systems, or borders. This is the ancestral mediation notes recommends. But my dream goes behind. I think that our mission is to establish mediation as a true profession, looking for more scientific evidence of the effectiveness of mediation. Or, if you prefer, make it the default gym gear in the field of dispute resolution. We count on you to endorse to promote UDPM and make it truly universal. I thank Alvin, I thank Joel for inviting me, and I thank you all for listening to me. Thank you.
Thank you, Anna, and it's nice and refreshing to know that there is progress made on this universal protocol on disclosure. It hasn't quite come yet to this part of the world, but I think we can draw inspiration from the progress that's being made on that front. Now, with that, I think we can have some time for Q&A. We've got a couple of questions that's come across to the panel. And I think I'll take up one of these questions. It's quite interesting. And the question asks whether or not we could, with mediation, allow some of the mediated settlements to be published or to be shared. I think pretty much the same way as we would share court decisions or even arbitration decisions, and whether or not this could benefit some of the other parties. And maybe some safeguards would be redaction of the settlement agreements. I don't know, if you ask a lawyer whether you should publish some of the settlement agreements, I don't know, Chen Yang, if you win a case, you want everything to be published. The name of the lawyer, what his charge-out rates are, and everything. But you lose a case, you want everything to be redacted. You want the entire case to be thrown out, right? You don't want anything to be published. So I don't think we'll ask lawyers about this. Nish, as an end user, would you think you will support some sort of a limited disclosure of...
Guess.
Yeah. What is your guess?
Yeah, what's the guess? Well, I think I see point to this. If we are talking about professionalism and if you're talking about quality, there has to be more understanding of how things are moving in mediation space. If you do not have settlement document, or if you don't, so this is how I'm envisioning. If I have to say yes, I would like that. Like party A, party B in industry tech dispute on a dispute was about perhaps IP, so we can talk about the nature of dispute. We can talk about duration of mediation. We can also talk about the value of dispute. We can talk about the cost at which the whole mediation process ended, like the cost of mediation. I think WIPO is already doing that. If you check on their website, they do have that kind of description for mediation disputes. So this kind of information, I think, should be made available. Yes, we can't talk about who was the mediator or the law firm, but this can certainly help us position it back that industry is opening up to mediation. Things are happening. This space is evolving, just like all other ADR tools. Unless, Sapna, you are here, unless you are a lawyer yourself, I think I have not said anything which is inconsistent with those confidentiality principles of mediation.
Right, thank you very much for that, Nish. I think we can't say that we are closed off to the idea, but of course we obviously would need to protect confidentiality of the information, and not use that or allow that to develop into a deterrence, right? Yes. To come into mediation. Okay, we move on to the next question, which is interesting. The question says that, mediation used to be voluntary, it used to be conciliatory, amenable. People come to mediation because they're all interested to come to mediation, all agreeable to come to mediation. Now, will things change if you begin to mandate or to require mediation to be a step to be taken? Would that add to the process of dispute resolution, make it more costly? Would the process of mediation itself constitute a detour that makes it even more cumbersome for parties to come to mediation? Are there any means to alleviate such concerns? There are 4 or 5 questions in that question.
Yes.
We need a top-notch dispute resolution expert to deal with that. Chern Yang, would you like to try to deal with that?
The direct answer to the question will be yes. And then I move on to the next question. What's staring at me at this question is the front part, which talks about mediation used to be a voluntary, conciliatory, and amenable forum. And I think from my perspective, it still is. Having standards and having high standards of your mediators do not change that. In fact, it encourages them to do it better. And I think that is what we're talking about today. What is the quality assurance? In the sense that if you have a community dispute, what is the quality assurance that you go to someone who puts himself out there as a community mediator? You have the assurance that, okay, this mediator knows exactly what is going to happen, can understand the ins and outs of my concerns, and has the skill sets to be able to navigate through the process, as Dorcas has put it, the assurance in the process itself being assured to them, to give them the sense of fairness, being treated with integrity. And likewise, for someone with a medical negligence complaint, what is your assurance to that particular mediator that you pick? Having the right medical background knowledge so that you don't have to spend the first half of the day trying to explain medical terms to that mediator. And I think having that structured process, codes and regulatory framework, encourages the users to have the confidence in the mediator and in the mediation process. And that, I think, can only augur well for the improvement and the development of the mediation industry. So my thoughts, Ming.
Thank you very much, Chern Yang. Is there anyone in the audience who has a different view or anything to add to that? What other means of safeguard do you think we can bring to bear?
I think Sapna wants.
Someone raise a Sapna. Yes.
Well, firstly, thank you so much to the panel and the moderator. I've really enjoyed these presentations, which have been excellent and very diverse. I think we all agree that quality assurance for mediators is absolutely paramount. And I just wondered if institutions have been looking at feedback forms for mediators. One of the things I've noticed is that when you look at accreditation standards for accreditation bodies such as SIMI and other international bodies, there's a real focus when you look at the different levels of accreditation on the number of mediations a mediator has done. Now, while it's obvious that the more you do something, the better you will get at it, I think there is a bit of a concern that it can make the barriers to entry very high. And I wondered if we looked at more qualitative feedback and moved away from quantitative assessment of mediators' capabilities and standards, and a bit more towards qualitative, could that mean that we could still keep quality assurance, but we might be somewhat reducing some of the barriers to entry? So a slightly complex question, but I did see one of our panelists, or a couple, nodding that maybe this might be a good idea. I'd be interested to know if any institutions have thought about this.
Thank you very much, Sapna, from the AGC. And I think when the AGC makes some recommendations, I hope someone is taking notes over here. Try to get some of that on board. Okay, I think, I picked up a question from Dorcas's presentation. And I think, Dorcas, you meant something, you just mentioned something, probably in passing, about whether a mediator should give their views. In the course of the mediation. And we know that, well, this is very personal. It comes down to the mediator. Some really just want a very facilitative way of mediating, and you just come down a little bit more, and you just come up a little more, and then we meet somewhere and everybody's happy. Some are a little bit more prescriptive, and especially those maybe, comes from a judge's background, and, this is right and this is wrong, and I tell you, if this case comes to my court, I'll throw it out, because, where are you going to find the evidence for this? We don't know. There's no right, no wrong. Maybe just as a closing question, if we can just go down from Chern, Dorcas, and Nish, and Anna, what are your personal views? I mean, do you think as a mediator and this whole process of just bring everybody to a destination where they are both happy, no real outright winners, but definitely no losers, do you think a mediator ought to share his views on the case, the merits?
I think it boils down to the question of what do the parties need. That's my very frank view. And if what the parties need to be able to continue and facilitate a more constructive negotiation means that the neutral's views may actually be useful in pushing that, then that's something I've never shied away from the mediations that I do. I know if I say that when I first started at the base level accreditation, I actually failed the assessment. I always liken it to the people I assess and accredit as mediators as to a driving test. At the base level, when you try to do a driving test, there are certain limits to what you can do. But once you're on the road, you've got to find out what works, depending on the traffic conditions and depending on what you actually encounter, the conditions of the day. And I think that's really what I think mediation is like. It's dynamic. You've got to change, adapt to what the parties need in order to advance their negotiations.
Okay, thank you, Chern. Dorcas?
I agree with what Chern said, just to frame it a bit differently. I think if you look at the idea of self-determination, so this is where sometimes we can be a bit, just say, same formula for everyone, right? So in a sense, what Chern highlighted is that different parties have different needs. Also, different parties have different views as to a different comfort level as to how much they welcome your views, right? So I've also seen many people where you give views, but it was really unsolicited. Nobody wanted to hear it, right? And that occurs quite often, you see. So and then on the other extreme, you might have some say, I would never give my view, even if it's something that's needed and they agree, they are consenting to it. So I think it has to be quite a nuanced approach, bearing in mind what you mean by self-determination. And so it does not mean that always don't, but is it needed? Do they want? And going back to what Anna said, even before the mediation, do you talk to them to say, that, do you want my views, right? Is there an appropriate time we want it, and when, see? So we have a good understanding when it does happen. And even when it does happen, to also still ensure that this is something that they really want and not unwelcome, unsolicited views because I just want to say how I feel, right? So I think it requires lots of sensitivity. And I like to echo, Sapna mentioned about quality. So things like this actually can come out in feedback. So both IMI as well as SIMI actually, they require you to submit the feedback forms. And that someone actually will comment, an independent mediator will comment on a whole body of your feedback and write a digest. So I think that's a good signal that it shows that you're looking at party satisfaction.
Nish, do you think this helps to have a mediator perhaps for you to cross-check against what your lawyer's been telling you, whether your lawyer is too much of an eagle, too aggressive, very, very victorious and optimistic, or whether he's a chicken, or maybe he's like an owl. I mean, he always nods, with a lot of wisdom, but doesn't say very much. So do you think it's helpful for the...
I think it's one of the most difficult questions to answer. I've been thinking, because she said she has used two things. First, feedback for mediators, A, and two, the more you do mediation, the better you get at it, but then there are entry barriers. Two things she raised, and I've been thinking about it as well, because I do see that why I'm not being appointed as mediator if there's a healthcare dispute, and I would be itching for it, that I think I can do that job better, not then the mediator. So my suggestion would be, A, that you can have a mediator, but there's no harm in having observers, maybe two, And those two observers can be at the option of the parties, who will be maybe from industry, maybe an expert, but their role will not be to mediate. They will be just observers. And those observers can provide their feedback to the institution if the mediation is being conducted under an institution. And that way, mediators should not have that pressure of getting feedback from parties, because that should not be the case, even in litigation, judge for neutrality of it. Because when you know that, and feedback, I think by parties, even when I'm doing 360, I'm being very honest, it will be subjective to your state of mind. It is difficult to write an objective feedback, even if you're writing 2 sentences. So don't give that pressure to a mediator. Let him or her do her job. Observer will serve the purpose, and that observer can be a future mediator. So barrier to entry would be lowered. That's what I was thinking as a solution, because that observer would be observing how mediation is conducted as well.
Thank you very much, Nish. Okay, no pressure to the mediator. All the pressure's on you, Anna. The last speaker on the last point. Should the mediator give his views?
I was listening to all the valid points, and I was thinking, I always say in the starting of mediation, my dear lawyers, if you have reached an agreement, we would not be here. So, if we are here in this mediation, it's bad because you need a third neutral here to help you reach something, an agreement, a better relationship, whatever. So that's, for me, it's the start. How are we going to do that? It's really, really contextual from my experience. And if you have a different experience, please share. It's really, really contextual. Each mediation is unique. Each party are unique. What culture would they bring? What lawyer, the way how the lawyers proceed, how do they do it? So I would not have one answer. I have one answer for each one of my mediations. And to conclude, before you just say, to finalize, this is the beauty of the mediation, because it can be really flexible and adaptable and respect self-determination. And that's why we need to have a common message to say what this is about. Otherwise, lawyers can say, oh, I mediate every day. Why do I need this third neutral? I do it every day. And he forgot the process, he forgot the quality assurance and the standards, the ethical standards that we were here today to speak. Thank you very much.
Thank you so much, Anna. And ladies and gentlemen, with that, I think our time is up. It's my pleasure once again to thank all of you for joining me and my panel on this sharing of views. And I also want to thank Chern, Dorcas, Nish, and Anna for their interesting and very inspiring sharing this morning. I hope that we've all taken away something from this morning's session, and it leaves me once again to thank the organizers and SIMI for this invitation, and to thank all of you for your kind attention. Thank you very much.
Thank you.
Well, ladies and gentlemen, I hope that today's panel discussion is just going to be beginning of more conversations by the industry. And when I say the industry, it means the mediators, the training providers, the service providers, businesses, consumers of mediation services, as well as even government officials, right? Conversations on how we're going to understand and apply, right, what we understand about standards, so that we can help professionalize the whole ecosystem surrounding mediation. Certainly for SIMI, we want to continue to work with the various business sectors and the mediation industry to talk about the importance of quality in mediation process and amongst mediators, and how accreditation achieves this. And so I hope that the conversations will continue from today, and leading to more convergence locally and internationally on how we can further quality in mediation, refine accreditation, so that mediation truly is recognized as a professional process. Mediators are recognized as professionals who can help resolve disputes efficiently and effectively. So we will be in touch, and we hope to work with all our partners, friends here today on achieving these goals and uplifting the industry together. So it remains for me to just say that I'm really grateful that we managed to get this panel going. Thank you very much, Mr. Locke, Chern Yang, representing also the Society of Mediation Professionals Singapore, to Assistant Professor Dorcas, right, to Nishtha, right, who was nominated by the Singapore Corporate Counsel Association, as well as Anna. Right, thank you very much for your time, and thank you to the NUS Law faculty for allowing us to host this event at the Moot Court here on Bukit Timah campus, and also my small SIMI team, Rafida, Melinda, and Kedip, for putting this event together, and our 4 undergraduate assistants from NUS and SUSS for today, Andrea, Caleb, Yutong, and Wei Teng. Not to mention all the staff and supporting vendors who have made this event possible. So it remains for me to just close the meeting and say thank you very much. Lunch, or rather brunch, is provided. We invite you to stay behind. Our ushers will usher you up to the 2nd floor of this building, and we can talk further. Thank you very much, and have a good day ahead.